Good evening from Singapore. My name is Kevin Nash. I'm the Deputy Registrar and Center Director of SIAC. On behalf of everyone at SIAC, we would like to welcome you to the latest installment of the Dialogue on COVID-19 with the SIAC Secretariat, where for this third session, and really following the lifespan of an arbitration, we will look at appointment and challenges of arbitrators, early dismissals, hearings and scrutiny, and the transmission of the award. As many of our friends in Singapore would be aware, today is the start of phase 2 in the Singapore circuit breaker, where we will all have a bit more freedom to meet up with family and friends. There could therefore not be a better time to have an evening drink as per the description of this session. We are going to drill down to the details on the substance, but we will also try to keep it a bit light and accessible in keeping with the evening event. Of course, as with all of these sessions, it is interactive. We have been getting very good feedback on our live chat feature on the SIAC website. As many of you would be aware, users are now able to go to the SIAC website and speak with an international arbitration lawyer on some of SIAC's processes and procedures. As we've mentioned over these sessions, we are heartened and very pleased that thousands of you have attended. Counsel at any institution, and particularly counsel at SIAC, are really the engines of the institution and people most responsible for SIAC's gold standard case management. And the counsel that we have with us today are three of SIAC's most senior, most and experienced counsel. I will start with some introductions. We'll start with Chen Wu, who is a Chinese qualified lawyer and has worked for major law firms in China and Europe. As part of her portfolio of cases at SIAC, she handles cases governed by both common law and civil law, PRC parties, and parties really across a range of jurisdictions. In addition to her work on commercial cases, Chen is one of the first people that we look to on investor state questions, and she is currently handling arbitrations in English, Chinese, and French. As a purportedly bilingual Canadian, I am starting to get concerned that Chen's French might be better than mine, but we'll perhaps figure this out at the end of that French language case. Additionally, as I recall, Chen, when she was in practice in China, also assisted with the enforcement of a few SIAC awards in China. Moving on to Kendista Wanta, who's counsel at SIAC and an Indonesian qualified lawyer who has practiced both commercial arbitration and commercial litigation, domestic and international, with leading dispute resolution firms in Indonesia. He also clerked for one of Indonesia's foremost arbitrators prior to joining SIAC. As part of his case portfolio, Kendista takes on the lion's share of cases involving Indonesian parties, but also works on some high-value construction and project cases, commodities, and international trade. Pauline Loh is a Malaysian qualified lawyer who was previously an associate in the dispute resolution group of a top-tier law firm in Malaysia. She is admitted as an advocate and solicitor of the Malaysian bar and fluent in English and Bahasa Malaysia. As is the case with all of our speakers, Pauline is an in-demand speaker on the arbitration circuit, and my understanding is that this is her second webinar of the day, so we thank Pauline for making time for SIAC. In terms of her portfolio of cases, Pauline handles a lot of complex matters. I have heard from more than a few users that she is hyper-efficient, and she is also fortunate, at least right now, to have some of the longest and most complex awards that she is currently reviewing. So that set the stage. We're very happy to have these three counsel with us tonight. I would again remind the attendees, please do ask us questions. This is the third in the series, so you feel free to make these questions very difficult. And let's start with the appointment of arbitrators. We've discussed the procedural tools, commencement, but now let's look at what really matters, appointment. The surest way to have a smooth running arbitration is to appoint a very good arbitrator. When SIAC is called upon to make the appointment, this might be a sole arbitrator when the parties can't agree. It could be the presiding arbitrator as a default mechanism for a 3-member tribunal, appointment on behalf of a non-participating respondent, or sometimes effectively the DUTCO multi-party situation where we will appoint all 3 arbitrators. So Chen, starting with you, I wonder if you could give us an idea of the appointment process at SIAC. What do you look at when you're recommending arbitrators?
Sure, thank you, Kevin. Very happy to be here this evening. So for the appointment of arbitrators at the SIAC, first of all, we need to clarify, appointments made by the institution and, confirmation of nomination of arbitrators by the SIC. So if you go to read the SIC rules carefully, you will see that all the nominations of the parties or the co-arbitrators need to be confirmed by the SIC. So for that scenario, the appointing authority simply exercise his or her discretion as to whether to confirm the nominated person or not. But on the other hand, as Kevin mentioned, in different scenarios, the institution may be needed for making the appointment directly. So there are a lot of considerations for the appointing authority to make the appointment. And we as counsel sitting in the Secretariat, one of our big missions is to assist with the appointing authority. So I got ample opportunities to observe how they make these decisions. The first consideration is, of course, the agreed any of the agreed qualifications. So if the parties expressly stated in their arbitration agreement that the sole arbitrator need to have at least 20 years practice experience, then we will probably choose someone who is senior enough to satisfy this requirement.
Actually, Chen, sorry, I don't mean to interrupt you. If I could stop you there. In terms of your cases, because we see this a lot where there's qualifications in the arbitration clause, but we also see proposals where instead of ensconcing it in the arbitration clause, one of the parties might say the president may wish to consider someone with more than 20 years of experience. How would you view that? Have you seen that manifest in certain ways? My preference, at least, I think it's better unless you're very sure, because 4 years down the line, those qualifications that were relevant at the time of transacting might not be the same. Do you see a bit of both proposals from the claimant and the respondent and also qualifications in the clause?
Yeah, of course. We see that the party is trying to, if their arbitration clause is clear about the qualification, it's okay. We know it's fixed, but we also have so many cases where there is no stated requirement of qualification, and then the parties wants to have their preferred candidates to be appointed. So in these cases, we will set out what the claimant or the requested or what the respondent has proposed for, and then we will propose some of the candidates based on the proposals. But these proposals are just a point for reference. It's not mandatory, unlike the agreed qualifications, which we will discuss later, that the agreed qualifications are so mandatory, failure of which may prompt the mechanism of challenge. So we just mentioned the agreed considerations. And another point which is not expressly provided in our rules is the nationality. So in our rules, we do not state that the nationality is the biggest concern for the institution to make the appointment. But in practice, correct me if I'm wrong, I see that the appointing authority is conscious about the nationality, and they try to avoid appointing, let's say, a sole arbitrator whose nationality, who shares the same nationality as one of the parties.
Yeah,
so,
that's right. Chen, I would add, in 4 years of working with you, I don't think I've ever corrected you once. But let me ask, so I think you're right, it's not expressed in the SIAC rules on nationality. We're always looking to appoint a neutral national, particularly say for a sole arbitrator. What about in the case of a non-participating respondent? If you had a Malaysian claimant and a Chinese respondent, the Chinese respondent wasn't participating.
Chinese non-participating respondent, which happens a lot.
So what would the nationality considerations be there?
Okay, so if it is a 3-member tribunal and let's say the Chinese party is not participating, what I have observed is that the appointing authority will try to find someone, that the respondent or the non-participating respondent may feel comfortable with. So in one of my previous cases, I see that the appointing authority appointed a Chinese national who's qualified in the common law and also in China to be the co-arbitrator on behalf of the non-participating Chinese respondent. Yep. So I think we really need to distinguish the identity of the arbitrator, whether he or she is going to be the presiding arbitrator, sole arbitrator, or co-arbitrator. So we have different considerations.
I think that's right. Sorry. So qualifications are considered, nationality, any other factors that we look at. And what I guess I'm trying to impart to the audience, and what I think is important and a big reason for SIAC's appointment process, is the counsel are generating the names. A lot of the things that we do at SIAC really are a two-step process. So counsel start by generating the names. It goes up to me or the registrar, or sometimes the registrar or I will act as the appointing authority, and then it's put to the president or the vice president. So you guys do serve an important function in terms of generating the names, and really because you are the guys that have the best sight of the case and know about the performance of arbitrators. So those are the first two. What else do you look for, Chen?
Of course, we will also check the experience. So if, let's say, if this is a construction dispute, you really want to appoint someone who has former exposure or who is an expert in this field. But again, experience is not mandatory, and you see that a senior enough lawyer may have handled a wide range of disputes. So experience is one consideration, but it's mandatory. And another very important element to consider is the amount in dispute. As many of you may be aware that under the SIAC system, the remuneration of the arbitrator's fees is based on the amount of dispute, unless the parties agree otherwise. So if the amount of dispute is high, then probably the remuneration is high accordingly. So let's say if you have a 1 million dispute, 1 million Singapore dollar dispute, you don't really want to have a QC to be the arbitrator, because for Queen's Counsel they're quite busy, and they are in a position to pick up the interesting cases. So we really look at the amount and to try to find a person who can commit time and also expertise on this matter.
If I could ask you about SIAC's confirmation process. So let's say there's we approach a sole arbitrator. This arbitrator has something orangish in terms of the disclosure. So has, say, something that would fall up in or around the orange list. We put this to the parties. The claimant says no problem. The respondent strongly objects. How does SIAC handle disclosures in terms of the confirmation process for both party-nominated arbitrators and institutional appointments? And Candice, Pauline, feel free to weigh in as well. But
right.
Go ahead, Chen.
Sorry. Yeah. So it happens from time to time that the candidates nominated by the parties or prospectively appointed by the SIAC make certain disclosures. And for most of the time, we will submit the disclosure to the appointing authority, and it's likely that they will instruct us to convey such disclosures to the parties for comments. Yeah. Sometimes one party agrees and one party will strongly object to that, for different purposes. And ultimately, the decision to proceed with the confirmation or the appointment rests on the appointing authority. So if it is on the orange list, and I mean, from my experience, I see that the appointing authority tend to proceed with the confirmation. But let's say if it is on the red list, either being waivable or not, I trust the wisdom of the appointing authority, and they will probably exercise their discretion not to confirm it. But I mean, from my experience, I've never seen any denial of confirmation from the appointing authority.
Yeah, it's very rare. Sorry, Pauline, go ahead.
Sorry, I mean, if I can just jump in, because I have a couple of situations like that, and I think it has to be remembered that the safeguard what we offer at SIAC is really the president's discretion to confirm or not an appointment. And I think it really then depends on whether it's a nomination by the party or whether it's an appointment made by the SIAC. I think an appointment at SIAC, the tendency is always to go for a lily white appointment, so it falls under the orange list. I think I suppose there is a tendency to not proceed with the appointment, but if it's nominated by the parties, again, I think we also look at whether the nomination is for appointment of a sole arbitrator, or would it be for a co-arbitrator. So there are so many factors to consider. I don't think there is a clear answer what the decision would be like if the disclosure falls under the orange list.
Yeah, it's an interesting issue, and really the IBA guidelines are just one of the many factors that you're considering both in disclosures and also challenges to arbitrators. One thing that we want to do at SIAC is that we want to encourage disclosure. So you want, sometimes people talk about an issue of over disclosure, but you want to have enough steel as an institution where if it's a minor disclosure that doesn't go to anything, the arbitrator for good order puts it to the parties. And even if a party objects, if it's a minor disclosure that doesn't go to independence or impartiality, you want to be able to proceed with the appointment. Of course, there are different considerations for the appointment of a sole arbitrator, chair, party nominee. But let's assume, as we often do, that the appointment goes correctly. Because if you look at, say, the last 5 years, the last 10 years of SIAC, there are very few challenges to arbitrators. In 2019, we only had 2 challenges to arbitrators. Chen, could you just give me an idea of the process for the challenge of arbitrators? Because I think sometimes the institutional process is, so let's say respondent files a notice of challenge against a sole arbitrator. What happens after that? What do you do as counsel, and what does the institution do? More in terms of process rather than what's guiding their decision of the SIAC court. Yeah.
Right. So, so first of all, I mean, before one party formally files its notice of challenge, they should remember to pay the challenge fee. So we see cases that one party files a notice, but they did not pay the challenge fee. Therefore, we could not proceed with the challenge. And be minded of the time limit under our rules. We have a time limit. So first of all, I would remind the parties to pay the challenge fee, and secondly, be minded of the timeline. So under Rule 15 of the SIAC rules, I mean, assuming that the SIAC Rule 2016 govern the procedure, the notice of challenge has to be filed within 14 days after the party became aware, or should be reasonably be aware of the so-called circumstances. So these are 2 things. And if these 2 are satisfied, and upon our receipt of the notice of challenge, I as counsel, I will submit the case and also summaries to the registrar and the deputy registrar immediately. And it's possible that one of the parties would require suspension of the proceedings. So under our rules, the registrar could order the suspension of the proceedings, but it's really on her or his discretion. We see some cases where the suspension is not ordered, and then under our rules, of course everyone in the other party, the challenged arbitrator, as well as other members of the tribunal, if it is 3-member tribunal, they should be notified of challenge. And so under our rules, we said that within 7 days, if the other party agrees with the challenge, or if the challenged arbitrator agrees to step down, then the SIAC Court of Arbitration will remove that challenged arbitrator and appoint a substitute arbitrator. But in case that there's no reply from these people within 7 days, or they express their saying that they do not agree, or the arbitrator does not want to resign, then this case will be elevated to the SIAC Court of Arbitration. So SIAC Court of Arbitration, they will review the challenge, and if they consider that further comments would be helpful, they can invite comments from the challenged arbitrator or the other members of the tribunal as the other party for consideration. And after their consideration of these various submissions, the SIAC Court will issue its decision, which is a reasoned decision. So this is generally what will happen. The general steps after the filing of a notice of arbitration. And just the last point. So the decision on challenge by the SIAC Court is final and is not subject to appeal to the SIC.
Yeah, but for Singapore, seated arbitration is appealable to the Singapore High Court within 30 days, de novo review. Chen, it's after 6 p.m. Be honest with all the attendees. How much work is the briefing to the SIAC Court of Arbitration on the challenge to an arbitrator?
How much work? Well, it really, I mean, for most of the time, you will see that the parties have submitted, voluminous submissions, and also with a lot of exhibits. So for me, I mean, personally, I'm handling 2 challenges at the same time, which is a lot. And you don't want, I mean, as a counsel, when I'm summarizing what they submitted, I don't want to, omit any of the points they raised. So, I mean, it's on one hand, I review all the documents and provide nice and comprehensive summary. And on the other hand, we will, I mean, Secretariat will assist the SIAC Court of Arbitration to draft decision on challenges. So, which is another, workload for me.
Yeah, I thought you were going to give a 2-word answer of a lot, because it is a lot of work.
I want to be
It's also
specific.
it's also some of the best work that you can get in arbitration, and it is critically important to give the fact that we do give written reasons on challenges to arbitration. Final question, Chen, on challenges, and then I will put an appointment question we have from the audience to all of you. What are the situations where the registrar would exercise the discretion to suspend the proceedings? What have you observed in your cases?
Okay, although I think Kevin is actually, in the best position to answer this. I will provide some of my observation. Kevin, please supplement.
Well, it may be observations on my decisions, but now I'll know if you think they were correct.
So in the challenges that I have handled, I observed that the registrar or the deputy registrar will consider if the tribunal has become de facto dysfunctional. So let's say in case where it's a sole arbitrator and there's upcoming hearing in 1 week or 2 weeks, it's possible that the registrar may order suspension just to pending the outcome of the challenge.
Yeah.
So
I think that's the classic example. An 11th hour notice of challenge, a hearing. What do? Do you exercise that discretion? But the discretion is important to this sort of filtering process to not completely disrupt an arbitration, even though we get very few challenges when a challenge does arise. The question from the audience. Sorry, please, Kadisa.
Thank you, Kevin. Just want to add a little bit from my experience in terms of what Chen mentioned as this dysfunctional tribunal. I actually experienced a case where a challenge was directed against, this is a 3-member tribunal. The co-arbitrators were both challenged and they decided to voluntarily withdraw from the tribunal. And because and then the presiding arbitrator was subsequently challenged. So basically, it is impossible for the proceedings to continue, and in that situation, the registrar decided to suspend. I thought I should just share one of my experience.
It's interesting, and I've heard, I guess by opposite token, I've heard arbitrators that really don't want to go through the hassle of a meritless challenge, assuming that there isn't merit, but the arbitrator felt like that as part of his mandate to the parties, it's necessary that he not withdraw and not allow an obstructionist technique to be successful. One of the questions that we had from the audience, and Pauline, maybe I'll put this to you on appointment. With COVID-19, are we appointing more Singapore-based lawyers? What do you see in terms of the tenor of SIAC's appointment in terms of geographic regions and the impact of COVID-19?
Well, I think at least for my cases, I don't see that. I don't see, that we're appointing necessarily more Singapore arbitrators. And I think one of the reasons is because I think arbitration is, in such a way that you can really do it remotely. I don't think you have to be in Singapore in order to be able to, run a case that has, that is in Singapore, for example. So I think like what Chen has mentioned earlier, nationality is something that we look at, but it's not only the only factor that we look at. We look at so many other things. I don't think we have the time to, really consider all the factors. And I see you smiling there, Kevin, you would know. So we don't see that. I think we really go for merits, if you ask me. We really go for merits. And so that I think that has to be the overriding consideration. I mean, on top of things like bias and things like that.
I could not agree more. And your philosophy of appointing the best in the world, that's what we're doing. And to a certain degree, COVID-19 has made the world a bit smaller, especially with the increased use of virtual hearings. The main issue starts to become time zones. Of course, there are a lot of excellent arbitrators based in Singapore, but it does give a bit more flexibility because the parties won't be incurring any additional costs. One thing, of course, that I've seen all of you guys recommend and what's really helped have global appointments for us is previously, in the previous normal, we would appoint arbitrators on smaller value cases on the basis that they would bear any travel expenses, because we don't want geography to be a factor. We want to appoint the best in the world. Okay, that's very good. So we have appointed an arbitrator. This arbitrator has not been challenged, or the challenge has not been sustained, but a party is looking to advantage themselves of SIAC's early dismissal procedure that was introduced in the SIAC rules 2016. Candice, could I possibly call upon you to give a general background, because this is relatively new, at least in the commercial space. What is early dismissal? How is it working? How often are we seeing it? A general overview, if you could.
Sure. So early dismissal, I think we introduced this in our 2016 version of the rules. Basically, it is a procedure for the early resolution of a dispute. It allows a party to file an application for the early dismissal of a pleading. So rather than let it go all the way to the full evidentiary hearing, by which time the parties will have incurred more cost and time for the arbitration. This procedure, I think, is very similar with the summary judgment and striking out procedures in the common law. I think they are commonly used in court litigation. And under the SIAC rules, we have two bases to make an application for early dismissal. The first one is if the pleading is manifestly outside the tribunal's jurisdiction. And the second is if the pleading is manifestly devoid of legal merits. So those are the two bases. Unlike our other procedures, this one is only open after constitution of the tribunal. And even though we introduced this in 2016, and it's, like you said, a very new procedure in the international commercial arbitration, we do see a number of usages in SIAC cases. I think last year it's more than 20 early dismissal application have already been submitted, if not much more. I think that's the general idea.
It's an exciting thing to see, because I think that most people would agree that tribunals have the power to deal with claims at an early stage, even if it's not expressed in the rules. But I think what you do by codifying early dismissal is that you give tribunals a bit more courage. And especially because this is adapted from the investment space to the commercial space, and I'm wondering if it's consistent on all of your guys' cases. I think first what we saw is people raising the specter of early dismissal. So you might have a claimant say that we're going to apply for early dismissal or a striking out in terms of this head of the respondent's counterclaim. Maybe they didn't go through with it, but they would be raising it. But as users started to get more and more comfortable, I think for all of you, and certainly for us, we see early dismissal on a reasonably regular basis. So I'm actually arguing against interest. I'm pretending to be the reasonable or unreasonable man on the street. It's called early dismissal, but it doesn't have the 30 days from the constitution of the tribunal like in ICSID. So can you give, I guess, at least an explanation on, can you apply at any time? What is this two-stage process? Why is there a two-stage process? How does it work? And would you agree that it should be called early dismissal? Again, an argument against interest.
Right. So yeah, interestingly, because we adopted this concept borrowing the idea from, like you said, the ICSID rules, Rule 41.5. Although the difference with our rules is that we are, like you said again, not barred by the 30-day time limit after constitution of the tribunal. So in the SIAC rules version, parties can file the early dismissal application at any time after constitution of the tribunal. So in a sense, we give more flexibility to the parties in using this procedure. Although we do realize that this flexibility could also be potentially abused. So that is why we put in place this two-stage process. Basically, upon receipt of an early dismissal application, the tribunal will first assess if the application should be allowed to be examined. This is to filter out frivolous applications, for example, those made purely as part of dilatory tactics, submitted on the eve of a hearing, and if allowed, then that means the hearing will have to be rescheduled. This would waste more cost and time. So those kind of applications can be filtered out at this first stage. But if the application is allowed, then the parties will be given an opportunity to be heard by the tribunal, following which the tribunal will then issue a decision within 60 days from the filing of the application. So I think if you see it early in the sense of at the early stage of the proceedings after constitution, it's slightly different, but obviously this could dismiss a claim without having to let it go all the way to the full evidentiary hearing, which is the final phase of the arbitration. So I think that's kind of the difference, Kevin.
And how about, sorry, Pauline, go ahead.
Sorry, Kevin. I just wanted to say that I completely agree with Candista that exit decisions are useful, but they're not binding. I think all of us saw parties citing them in their submissions, and tribunal referred to them but they're not binding. And we have seen the early dismissal used in very creative ways. That's has been used to strike out, for example, the respondent's defense that it is unable to pay deposits. In the case in an application for reimbursement of deposits. So I think what's happening at SIAC here is that we are really developing a jurisprudence of how early dismissal can be used. It has also been used, it's in one of my cases, it has also been used in a straightforward case of non-payment of debt. And Kevin, I know that you are involved in the UNTITLed working group on this, and you probably have a more nuanced view. Candista spoke earlier about abuse, and I think this is particularly critical in the situation where you have both the case being conducted under the expedited procedure and at the same time an early dismissal filed. Because if you look at it realistically, you will get an award within 6 months. And so what is the purpose of you filing an early dismissal application? So the two-tiered process really does allow the tribunal to look and see whether there is justification to file an early dismissal application, especially if a case is conducted under the expedited procedure.
That was an interesting aspect, and I believe that you and another counsel asked me at 1 a.m. because in the working group, I believe the last intervention of the day, the discussion was, can you have early dismissal within the context of the expedited procedure? And you've had one of those cases, and I think what's particularly important about early dismissal is the fact that we have the review of the awards. Can you just give us a bit of a flavor of what your experience has been with early dismissal? Does it work within expedited procedure? I guess it's a bit case by case to a certain degree, but it can work. I guess that's what the Untitled working group was looking for. Can it work? And I think the answer perhaps yes.
Can I just add one thing regarding the timeline? I know that Rule 29 has not provided any time limit for filing the ED application, but I personally do see that if the ED application is based on the second one, which is that tribunal that claim or defense is manifestly outside the jurisdiction of the tribunal, it's arguable that this ground can be used in combination with Rule 28 jurisdiction of tribunal, which has a timeline for reason jurisdictional objection. And I saw some parties use this in this way. I'm not saying it's right or wrong. I'm just saying they can really read through our rules and find some interesting interaction between those rules and make use of them.
Great point, Jen, and I think you're exactly right. I can remember talking to a senior professor, and I was talking about the proposed introduction of the early dismissal, and I said, well, I guess this could potentially lead to 3 bites at the cherry on jurisdiction. And he said, no, not could, will. So you do have that ability. So it could be at the prima facie stage, at the manifest standard stage, and then jurisdictional objection proper. But exactly to your point, the timing may be different, because even though I think the manifest standard would be lower than jurisdictional objection under Rule 28, it could be done later in the day and after the timeline. Candista, moving back to you, and I would put it to all of you generally, what would you say is the utility of early dismissal in the context of COVID-19? And if any of you have observations on what you're seeing out of COVID. What kind of cases are arising out of COVID? But Candice, to you particularly, what is the utility there? My first thought is boundaries of a force majeure clause, but I leave it to you to answer.
Thank you, Kevin. So probably a little bit of background first. COVID-19, as we all know, has disrupted economic activity on a global scale and could potentially lead to defaults in many commercial transactions. Disputes may be inevitable, but on the other hand, parties may need to have them resolved swiftly. I mean, they need fast cash. So early resolution of disputes, I think, is preferable in these challenging times. So in these circumstances, I think procedure like early dismissal would prove extremely useful for disputing parties. So on this basis, I think this procedure would be employed by parties even more going forward. But then it is interesting that you mentioned about force majeure. I think the issue when it comes to early dismissal in the context of COVID is in relation to force majeure. Many have predicted that COVID-19 cases will involve force majeure arguments, and then I think people can reasonably wonder if early dismissal could be applied against such arguments. Because the thing is, force majeure arguments are usually heavily focused on facts, which may not be suitable for early dismissal arguments, because the basis for early dismissal are restricted to legal merit and tribunal's jurisdiction. So yeah, I think that's the challenge. But in cases where it is quite clear, I think tribunals should not hesitate in exploring and deciding on the early dismissal application, even in the case of force majeure with the COVID-19 backdrop.
I'm going to go back, or Pauline, did you have a comment or an observation?
Yeah, so well, Kevin, I know you're the moderator and I shouldn't be asking you questions, but I feel that I have to, because I know that you're behind the revision of some of our rules, particularly the 2016 rules, where we decided to include the early dismissal provision in the rules. And so I just wonder, in the context of COVID-19, I think we see some respondents trying to buy time, trying to not participate and come up with excuses, or try not to, just not participate. And I wonder, when the decision was made to include the early dismissal provision in the rules, whether one of the considerations is to sort of overcome the situation, because as a respondent, if you have a provision in the rules which will allow you to say, well, the claimant has no case against me, wouldn't that be the better thing to do, to just say, well, the claimant has no case, than to keep quiet? I don't know, I could be completely wrong, but I would be interested to hear your views.
I mean, you hit on the better part of the deliberations about this rule. Should it be early dismissal of just a claim or early dismissal of claims and defenses? I think that everyone gets a little bit uncomfortable when you start saying that there's no good defense to this claim, and we start worrying about potential issues of enforcement. I think it actually might have been on your case. I think what's important when you're talking about the early dismissal of a defense is that the claimant still has to prove its case. So just by virtue of striking out a defense, particularly an affirmative defense, does not mean, to put it at its most simple, that, okay, the claimant wins. The claimant still has to prove its case. This again goes to the importance of the scrutiny process, because we're able to scrutinize these awards, and sometimes able to scrutinize the decisions as well. So there's a lot of different trade-offs, and really the 30-day time period that we were talking about with Candice that you see under ICSID, the trade-off and the reason why we have the two-stage test is because there's not the 30-day period. So really, if we had a 30-day period, so 30 days after the constitution of the tribunal, then you might not need this two-stage test. But because sometimes claims and counterclaims will take a bit longer to crystallize, we wanted to allow that possibility, but we also wanted to avoid sort of patently obstructionist applications for early dismissal, and that's why we have the two-stage test. So I guess it's one of those things, because we were introducing it into the commercial space. When you're drafting it and you're deliberating internally, you never know how it works. One thing that I'm quite heartened by, and I like it every time I see it, is the fact that a lot of the other institutions have now introduced, whether by guidance note or expressly in these rules, the same provisions. I think that's what's very good about institutions overall, is institutions are looking at what are the other provisions here, what could we be doing better, and I think in this case, in terms of the 2016 revisions, is actually looking at the user comments. I know, and the counsel that were working with me in 2016 know, there was more than 1,000 comments, and there were complicated charts and graphs, and you were going through all of this, but we're seeing what do people want and how can we put this into effect. Let me just circle back a little bit because we're getting a lot of interesting and quite complicated questions. I don't mean to scare you, but these are from very senior and eminent arbitrators. But I think it is an important point, and perhaps a simple answer though I would put to Chen or on the panel. So this ability and this discretion of the registrar to suspend the proceedings in the context of the tribunal or in the context of a challenge, does the registrar consult with the tribunal on whether or not to suspend?
From my experience, no. And I do think it's not desirable for the registrar to consult the tribunal because the tribunal always has the interest to proceed with the proceeding and to push the proceeding to the next step, and now they're challenged. So I think it's not in the best interest of the parties to consult, for the registrar to consult the tribunal at that stage.
And staying with Rule 15.4, can the registrar effectively make a sua sponte decision? The registrar, on her or his own volition, can the registrar decide to suspend the proceedings without an application?
Okay, so if you go to read our rules. I mean, I have the rule with me at hand.
I've done it with
okay,
without an application. So, but I may be wrong, and I defer to you, Chen.
Okay, so in two of my cases, both parties have made the request to suspend the proceedings. I think in theory, the registrar, can, from the point of procedure, to suspend the proceedings. But I personally have not witnessed this occurrence before.
Okay, it's an interesting question. So back a bit from challenges. The question that is coming is, what is SIAC's stance on gender diversity in arbitrator appointments, and how does SIAC try to achieve that stance? Chen or any of the panelists, do you want to comment on this?
Please go ahead, Chen. No, please go ahead, Chen.
Okay, so I think for all the counsel in the Secretariat, we all know that the appointing authorities as well as the institution itself, we emphasize a lot of gender balance, and for most of the time, when we counsels try to pull out a list of candidates to be considered by the appointing authority, we try to balance the names a bit and propose more female arbitrator names. So,
yeah, I mean, Pauline, go ahead.
Yeah, I just wanted to say that I think SIAC is definitely pro-gender diversity, and not just in appointment. If you look at the Secretariat, I think you can see there's good balance there, I would say. And obviously, I think when it comes to appointment, again, as I've mentioned earlier, I think we appoint based on merits. And I think when you talk about gender diversity, really we are appointing based on merits. If there is a female arbitrator who is suitable for the task, then she will be appointed regardless. I mean, not so much of the fact that she is a female arbitrator, but that she has merits. I mean, that would be, I think, our position, unless Kevin disagrees, of course.
No, that's very important. What we're trying to do with our commitment to diversity is evolve beyond the antiquated and perhaps not effective old way of doing things. So everyone will know we have funny rhymes like old, pale, and stale, or that there's 10 arbitrators in a certain jurisdiction. These are the only ones being appointed, but really we're guided by wanting to appoint the best in the world, and it goes far beyond just gender. And I think it's important that the attendees know how much time counsel spend on this. So it's gender diversity, it's generational diversity, geographic diversity, the intersectionality of diverse characteristics. It's always not immediately apparent. There's both visible and non-visible diversity. So sometimes we'll be appointing someone who just happens to have diverse characteristics, but is also the best arbitrator for this dispute. And I think that's important. Okay, so we've dealt with the appointment of arbitrators, challenge of arbitrators, early dismissal, whether it's been successful or not successful. Eventually, we're going to get to the award. So SIAC, we talk about the scrutiny of the award as one of the biggest value adds that we have. Not every institution does it. You guys actually all look good today, but I know all of you, you have a lot of awards that you're reviewing. Pauline, can you, because it's effectively a term of art, scrutiny, but what is scrutiny? What do you do? What does the registrar and deputy registrar do? And what is the interaction with the tribunal? I think it's actually not explained enough. What is the process? You've just received a 500-page award. What do you do next?
600.
600. Okay.
600. Thank you so much, Kevin. Well, you mentioned earlier scrutiny of awards, but I think you would agree with me that we scrutinize more than just awards. Sometimes we do it for decision as well. And I mean, if you were to ask us, we would love to scrutinize everything. We would love to, but of course, under the rules, we have to, the awards would have to be scrutinized before they are issued. It is a value-added service that we provide at the SIAC. The intention is really to enhance the enforcement of the award. SIAC is not the only institution that's doing it, but what I can tell you is that the scrutiny at the SIAC is very, very comprehensive, and it's actually a two-level review. Counsel, Kindista, myself, Chen, and the other counsels at SIAC will be doing the first level of scrutiny, and Delphine and Kevin would be doing the second level of review. I think what we need to know and understand from this is that the scrutiny really, which is a review of award or documents issued in the arbitration, really is secretariat driven. And the importance of that is that it allows us to be able to do it in a very quick manner. We have done it in a matter of hours. I see Kevin nodding away there. I'm sure you're recalling the many number of cases that have done.
Recalling missed weekends. Missed weekends.
Missed weekend and missed Christmases, missed New Year. Right. So what do we look at? What do we look at when we do this scrutiny? I take a very detailed approach. And I do that because I know Kevin is very detailed and I want to catch all the errors and not have Kevin tell me, oh, you missed this.
So
right?
what are some of the things that you've caught in terms of misses? Because this is a bit of the opaque process, and it's really what SIAC counsel, Delphine, me, we spend a lot of our time on. What are some of the misses that you have caught that may have went to enforceability?
Right, absolutely. So what we do is we compare against the grounds for setting aside. So that would be super important. That's what we look at. So we make sure the parties' names are spelled correctly, because there's no point getting an award against the wrong party.
I've seen it. 6 months after a party asked if they could change. 6 months after the final award, a party asked if to change the identity of the respondent, and the name was quite incorrect. Unfortunately, I think officio might make that decision. So yeah, that's important, and it happens.
Yes, and it happens very often as well. And sometimes you even get the claimants' counsel getting their own client's name wrong. Yeah. So, which is why that's number one on my list. So get the parties' names right. We ensure that all issues are dealt with, because otherwise, you get a situation where you have the award and then there's an application for additional awards, correction of awards. We don't want that. I think parties don't want that. Nobody wants that. So we try to make sure that all the issues are dealt with. We make sure that the key procedural events are set out in the award, because we are looking at things like due process. You want, to ensure that if there are things that would go to the enforcement of the award from a procedural standpoint, you would want them to be included in the award. We also do things, very editorial things, like we make sure that the footnotes are cited correctly, quotations are reproduced faithfully, mathematical figures are correct, pages are numbered, paragraphs are numbered. We look for typographical errors. But if I can talk more about cases involving non-respondent, and both, I think, Kevin, you know, the two of us have done a number of cases like that. I think a lot of people think that scrutiny starts after the award has been submitted to SIAC. I beg to differ. I think the process starts way before, because we are copied in all of the correspondences, and we ask that the parties, that the tribunal copy us in all of the correspondences. So in cases where the respondent is not responding, even in the early stages of the proceedings, we would remind the tribunal, for example, when sending emails, to ensure that they're using the delivery receipt function. And then when we receive the award during scrutiny, we would remind the tribunal to, you know, state in the procedural history whether there are any email that has bounced back. So these are just things that we do, and I think our users, they love it. I do think, especially younger arbitrators, they appreciate it. Even more senior arbitrators as well. I have, not just myself, I'm sure Candice and Chen as well, you would have gotten emails from arbitrators thanking you for noting certain things and pointing out, you know, certain mathematical errors. You would think that getting a number wrong is a small thing, but it can be a huge thing. Sometimes a matter of the placement of the comma itself could make a huge difference as to whether it's in the millions or in the billions. So I mean, these are just some of the things that we look at, Kevin. And of course, sorry, again, I know you are the moderator and I shouldn't be asking questions, but only because you are doing the second level of review. I just wonder, you know, as you know, what are the things that you look at? Are they different from the things that we look at, or do you look at all the same things again?
Yeah, I mean, well, I mean, I'll start a bit earlier in the arbitral process. Your point about that enforceability and enhancing enforceability doesn't start at the scrutiny process. It starts with SIAC counsel at the outset of the case. So particularly in the situation of a non-participating respondent, making sure that if we're sending all of our institutional correspondence, we might not have an email address. So we're sending that all by courier. We're prompting and reminding the tribunal of the existence of a non-participating respondent. Sometimes what can be a bit more troublesome is actually the intermittently participating respondent, a respondent that may appear for a bit and then go away again and then get back and ask for extension. So you're quite right that the enhancing enforceability starts at an earlier stage. I guess I'm fortunate in that I'm able to take a broader look at things because you guys have done the very thorough first stage review. One thing that I would like to communicate to all of the attendees, because I've heard it from some senior arbitrators, is that SIAC counsel are reading all of the pleadings. The way that it was put to me is that sometimes arbitrators might be a bit reluctant if they think that the counsel doing the first stage review has not read the pleadings. But counsel read the pleadings on the scrutiny and have likely been reading all of the pleadings during the pendency of the arbitration. So they're quite acquainted with the case. I mean, we could all tell, I think, a lot of war stories about the scrutiny of awards. Sometimes it's more interesting to talk about the awards that we're able to catch or provide a bit of assistance. But the reality is most of the awards in SIAC arbitrations are excellent. And one thing that I say to people, the biggest reason why you want to work for SIAC is because you get to do the scrutiny of awards. You get to learn from some of the greatest minds in arbitration. You get to know the legal philosophy of each arbitrator. I won't say if it's one of you three. I can remember catching a counsel who was reading all of the awards of a certain very senior arbitrator just to get an idea of how does this person decide. Is this person a strict constructionist, or does this person look, say, at the equities of things? I mean, one thing that you do, and you guys would do as well, is that you're ultimately looking at the dispositive, and you're staring at the dispositive, and you're scratching your head. And this goes beyond, say, computational errors. Obviously, we're there, and we can catch those things. I don't know about you guys, but if there's a correction interpretation or an additional award, I actually feel bad. We don't get those too often, but that's one thing that we don't want to get, because that's why we're there. And I have seen awards without a dispositive. I have seen certainly reliefs that go well beyond the four corners of the arbitration agreement, but it's also very jurisdictional specific. There's certain idiosyncrasies in different jurisdictions where we have to be cognizant of things that are necessary for enforcement. I think we're advantaged of the fact that we have Candice and Chen here, because Indonesia and China, we have to be alive to some of those considerations. I will come back to your question, Pauline, but maybe I'll push it over to Candista for a bit. So what are the considerations for Indonesian enforcement if you're administering a case with an Indonesian respondent, or just an award that is going to be enforced in Indonesia? What do you look at, and what do parties need to be aware of?
Thank you, Kevin. I think generally the same as what Pauline has mentioned, but in terms of differences, usually the first point would be to remind the tribunal of the requirement of a power of attorney, because for a foreign arbitral award to be able to be enforced in Indonesia, the Indonesian arbitration law requires the award to be registered by the tribunal. So if the award is issued and party immediately go to the court seeking enforcement, that cannot be done. We already have a precedent that difficulty could happen if that is the way they do it. So a POA is required, and what we do, this is following up on what you and Pauline mentioned. So from the very outset of the case, we already, from the very constitution of the tribunal, we already reminded of this requirement. So, and then as we go by, before the hearing, we usually remind the tribunal again that the tribunal may wish to discuss about the requirement of power of attorney for the purposes of enforcing the award. And then at the scrutiny process, we also remind the tribunal again if this has not been raised. So I think that is one of the most important consideration that we do when scrutinizing Indonesia-related awards. Other than that, I think generally the same. Although we do pay specific extra attention when it comes to non-participating respondents, like you said, we even suggest to include that correspondence have also been sent by courier, so it shows that proper notice has been given to all parties in the arbitration, something like that.
Candista, I'm going to couch this next question very carefully, and I will just ask for your observations rather than providing legal advice. That's one of the frustrations at an institution, is that sometimes you want to provide legal advice and guidance, but you cannot. Is this tribunal able to issue a power of attorney after the award has been issued? And again, just by your observations. The reason why I ask is that if you had, say, a claimant against an Indonesian respondent, the Indonesian respondent did not have a counterclaim, and 2 days before the award, all of a sudden the tribunal had neglected to ask for a power of attorney, and all of a sudden that's happening. That would give a pretty good idea to the parties of what direction this award is going. What have you seen from that? And again, just your observations.
Right. So yes, only my observation. Technically speaking, I think once an award has been issued and the proceedings have been concluded, the tribunal is already functus officio and does not have any other power to make any other things in relation to the arbitration, except in relation to, let's say, correction of an award, making additional award, interpretation, which is time barred 30, 45 days, depending on the version of the rules. But other than that, I think the tribunal technically could not issue any other things. Although it's unique because in Indonesia, somehow there's this requirement. And to my observation again, it's a bit difficult to be able to enforce an award with this requirement. So in practice, it seems that the Indonesian court does not really make it of an issue if the POA is issued by the tribunal before or after issuance of the award. I mean, otherwise it will be very, very difficult to enforce a foreign arbitral award in Indonesia. So even though technically it's a bit, on the mushy side, but in practice, I think the court in Indonesia still accept, POA issued after issuance of the award.
Would you say the best practice, though, is to flag that out early in the case? And because you have most of our Indonesian cases, is that something that you would point out to the tribunal, that this is something that you may see down the road and you may want to deal with? I've heard some anecdotal stories at other institutions where this hasn't happened, and it's been a bit of a process determining, I guess, the boundaries of functus officio in terms of the issuance of the power of attorney. Is this something, as a matter of course, that you're raising with tribunals?
Yes. So actually, that's what SIAC has been doing, to my observation in respect of all Indonesian cases, we try to remind the tribunal from the very constitution stage, and then around the evidentiary hearing stage, and then at the scrutiny process. Of course, we don't really push the tribunal because we realize that there may be an issue of prematurely judging the case as well. So it's a very delicate situation, and we basically just remind the tribunal and leave it to the tribunal to decide how to best raise this with the parties.
Even though it's 7 p.m. and after business hours, Chen, if I could, I would put a similar question to you. Of course, you have Chinese language arbitrations, lots of arbitrations involving Chinese parties. Are there any particular issues from an institutional standpoint that we look out for in cases involving Chinese parties? I suspect this is going to be a similar answer to what Pauline had proffered on, that it really starts from the beginning of the arbitration, but we would certainly like your expert views.
Well, yeah, we certainly got a lot of cases involving Chinese parties, and fortunately, we see that nowadays many of the Chinese parties are represented by sophisticated law firms. I mean, including many very good Chinese lawyers. So those lawyers, they know the international arbitration procedure very well. They manage their clients as well as the proceeding very well. I don't see a lot of problems. But for those non-participating Chinese party, or a party who is not represented by good lawyers, I would pay a lot of attention as to the notification during the process of arbitration. And at this stage of award, when I'm doing the scrutiny, I would compare the list of issues to the decision made by the tribunal. As Kevin mentioned at the very beginning, that I assisted with the enforcement of 2 SIAC awards. I was working in a Chinese law firm before, but unfortunately, one of the awards was partially enforced because the decision in that award was ultra petita, which means that the tribunal has decided issues outside the submission to arbitration. So that is one thing I try to look at when I'm doing scrutiny involving those parties. As to the others, I don't see any particular difficulty in managing China-related cases. Of course, 2 years ago we got that very famous Nova Resources case, but that is exceptional. We can discuss separately. Except that I think the approach adopted by the Chinese court keeps abreast of current affairs, and they're becoming more and more friendly to international arbitration.
I guess the point for the scrutiny process is that we're not there to change the tribunal's mind. It is still the arbitrator's award, but we are there to draw the tribunal's attention to points of substance. Pauline, the question that you were asking in terms of what I look for, I think maybe a very common example, or at least an example that we see, is say a situation where you had the claimant has been substantially successful on all of its claims, and the tribunal decides that each party is to bear its own costs equally. The position for SIAC there is just to note that the general transnational position is that costs follow the event, and we're just so whether it's case law, we're just putting it there for the tribunal's consideration. So the tribunal is free to have it 50-50, or maybe the tribunal might decide that the claimant's costs are reasonable, but we're never there to change the tribunal's mind. We're there just to make sure that the tribunal is apprised of all of the circumstances. I think one thing that's important from hearing from Candista and Chen and Pauline is that really part of the increased sophistication of SIAC is that we now have counsel qualified in all of these different jurisdictions. So an award going to Indonesia probably has Candista on the case. An award going to China probably has Chen. An award going to Malaysia probably has Pauline on the case. Indian qualified counsel, Thea Vega, who I should point out is the backup moderator in this session. Say a Philippines case, now we have a Philippines qualified counsel. So we've done the scrutiny of the award. We're ready for transmission. Pauline, if I could ask you, during COVID-19, how has SIAC been transmitting awards? How is it working? Electronic signatures, wetting, best practice for tribunals. What have you been seeing?
Right, Kevin. Thanks very much. Just if I may be allowed to just deal with this before we go to transmission, and only because you have mentioned it, because you mentioned cost earlier, and I know you also do the second level review, and I don't think in our earlier webinars we have touched on cost of the arbitration, and I know this is something that's very much within the registrar's jurisdiction as something that you would decide after you have reviewed the award. So I think one of the advantage here is that with the SIAC is that the cost of the arbitration is pegged on a sum in dispute A. B, there is that cost determination process at the end of the arbitration, and it typically happens after we receive the award. And an advantage of that is that you really pay for the work that is done. You get the registrar who can go into the case folder and look at what has happened, look at the award, look at the quality of award. And just before I talk about transmission, and because I am myself very curious, I just want to know, looking at the award itself, like how big is that a consideration, the quality of the award, when you talk about remuneration of the arbitrators' fees?
That's a difficult question for post PM. Well, I mean, we have all of our internal milestones, but what you've hit on is the correct point, is you want to look at what's actually happened in the case. And no different from enforcement, you're really looking, in the case of a determination of costs, you're looking from the constitution of the tribunal to the scrutiny of the award. One thing that I think would be difficult, and that's why we run it this way, say between Delphine and me at SIAC, is that you can't determine the costs unless you've scrutinized the award. So if I'm determining costs, it can only be on a case where I've scrutinized the award and it's flowing from the recommendation of counsel. So you've had counsel that has been all the way on the case. So in terms of the quality of the award, I think, yes, we like to see very good awards. It doesn't need to be a novel. I don't think that arbitrators are getting extra credit for a very long award. So if you had a simple quality dispute under the expedited procedure, say a $1 million dispute, and the tribunal decides to write a 300-page award, I don't think that you get credit for that. And that is the advantage of the ad valorem system, both for the parties and for the arbitrators. When I'm determining costs, the hours are the last thing that I look at. The hours are effectively just to make sure, okay, is this within the general boundaries of reasonableness? I think the mistake on an ad valorem system is to start pegging it to the hours, because you could have an arbitrator do the same work. One arbitrator would spend 45 hours and another arbitrator might spend 200. So it is critical to look at the work actually performed. And I think that that's something that we're very good at doing in terms of the work performed. Pauline, I will give you a counter question on the basis of some of the feedback that we're receiving from the audience. So Rule 32.3 says that effectively that the registrar returns the award and scrutinizes the award as soon as practicable. What does as soon as practicable mean? How long does it take generally from an award being given by the tribunal to SIAC and then pushed back to the tribunal?
As soon as practicable means as soon as practicable. So it really does depend on the case. It depends on the complexity of the case. So if you have a very complex case, the documents are voluminous, obviously, it's impossible to do it within hours. But at the same time, if you have a very complex case, but we have very urgent timelines to meet, it is possible for us to, take a different approach with the scrutiny, look at really what's important and meet that timeline. And then you look at things like how the length of the award. So I have one over 600 pages. So I can tell you that I will not be able to do it within a day. I will have to take much longer than that.
I have heard that you're hyper efficient, though. You think you get that done in 1 day?
I think a day is, you're not talking about hyper efficiency, you're talking about an impossibility. So I don't know. So I think we look at so many things, but typically if I have to give you a figure, I would say it would be 2 to 3 weeks. That would be, and I say 2 to 3 weeks because as we mentioned earlier, there is that additional cost determination process, and that is actually the time taken to finalize the cost determination, and not because that is the time taken for us to actually complete the scrutiny itself, but really to also look at other things like cost determination.
I guess in a similar vein to that question, the award has to be rendered 45 days from the closure of proceedings. What is your practice, all of you, in terms of prompting the tribunal? Because I think that we all know that very old arbitrator trick whereby you can spend months and months drafting the award and then close the proceedings. So once closing submissions come in, are you then prompting the tribunal to close the proceedings? How exactly do you do that? And I guess, Pauline, I'll start with you.
Well, in my experience, at least for my cases, I think arbitrators are now very sophisticated. They're aware of this. And I think many arbitrators don't start writing the award after the hearing. You know, usually the writing of the award starts way before. And we don't see many situations where, you know, after the close of submissions, the arbitrator then takes like a year or two to submit the award. We don't see that happening very often. I think most arbitrators would be able to submit it quite fairly quickly, and while everything is still fresh in their mind, they would, you know, just proceed to sit down and, you know, complete and write their decision. So I myself, I don't actually prompt the arbitrators. I think they are very aware of the timeline. It's in the rules. Parties are aware of it as well. But of course, what we would do is, if the tribunal then makes the decision to close the proceedings, because clearly in the rules, there is that 45 days timeline for them to submit the award, we would be mindful of that because they're copied in all the correspondence. So we would remind the tribunal that now you have 45 days to submit us the award for scrutiny.
Yeah. And it's a bit case specific as well. If it was a $4 billion major project dispute, I don't think the parties' expectations would be that the award would be rendered, say, 15 days or 20 days from the close of proceedings. We have about 5 minutes left, so we're going to address some of the audience questions. I think this is a very good question that I will put to Chen, because you've covered challenges, or really to any of the panelists. And the question is, how can one more effectively make submissions that better facilitate the registry's process of summarizing submissions and drafting of the decision on the challenge? I have some pretty strong feelings on this from my time long ago as counsel, but Chen, being that you're dealing with quite a few challenges right now, is there a way that submission should be formulated?
Well, I think, okay, so I think first of all, you know, the challenging party should be aware of the grounds that they rely on. So under our rules, you know, we generally have 2 grounds. The first would be whether the you know, particular person has the requisite qualifications, and second is well, whether there's a lack of independence or impartiality. So first of all, identify the grounds clearly, and secondly, you know, just to apply those facts to your arguments in a neat way. We see that, you know, some of the parties were making challenge on arbitrators. They try to cherry pick, and, you know, and use very colorful. They color the language in order to, you know, mount a robust challenge. But the real fact is, the SIAC Court of Arbitration, when considering the challenges, they will look at they will look comprehensively. They will check in what context does the arbitrator or the party made such statements or have this conduct. So I think, you know, really it would be good if the parties could provide, you know, a neat summary of their arguments, because anyway the SIAC Court is going to check the submission or the context in a comprehensive way.
Yeah, I mean, it's not too much different than your submission on the merits of the claim. So you can have many alternatives further and further in the alternative, but you might want to focus on your main claims, because no matter what, whether it's the award or the decision on the challenge, it might have that paragraph that says the submissions in this challenge were many, and all of the submissions should be considered to be subsumed within the SIAC Court's analysis. So all of the submissions will be considered, but the question of whether you want to take a very broad brush approach for all of the different grounds, because usually there's just a few triggering factors, particularly in a challenge, which might go to the arbitrator's independence or impartiality. We have a very good question. We haven't touched on this exact issue tonight, but I would open it up to any of the panelists, or I may try to answer this as well. So the question is, effectively talking about early dismissal, SIAC also has expedited procedure and emergency arbitration, and there's a 2-part question. would non-compliance with a multi-tier arbitration clause stand in the way of reliefs under the SIAC emergency arbitrator provisions? So let's start there. I open it up to any of you. If I see any hesitation, I may try to stumble upon this myself. What have you guys seen in terms of preconditions? Maybe I'll just set the stage a little bit. The position in Singapore, following on Lufthansa and its progeny, is that you're generally going to have to comply with preconditions. But in the context of an emergency arbitration, whether or not these preconditions would affect the emergency arbitrator's jurisdiction is a bit of a different story. Any observations or comments from any of you?
Okay,
I will take that. Okay, I was about to take my answer as perfect, but Chen, please go ahead.
No, Kevin, please go ahead. I'm sure you have a perfect answer.
Well, I mean, the emergency arbitrator is able to rule on his own jurisdiction, and this without prejudice to the tribunal's jurisdiction. But with most arguments on compliance with pre-arbitral steps are ultimately very fact specific. It is effectively going to be maybe a nebulous or vague requirement to have pre-arbitration negotiation. And you're going to have one party that says, I complied with this, and the other party that says, no, you didn't. And so that's a bit difficult for an emergency arbitrator to determine. So, okay, so we'll leave that for a bit, but let me go to the second part of the question. Are emergency arbitrator provisions intended to act as a substitute for court-ordered interim measures under the Singapore arbitration statutes? So I will let me take a stab, Chen, unless you would like to.
I think it's a matter.
Yeah, please.
I think it's a matter of choice, Kevin. I mean, basically, parties have the options of either go through the court for the interim measure or go to the arbitration. And I think from a tactical point of view, each has its own pro and cons. So I suppose it's not intended to replace, but it's really options for parties to decide which route it would like to pursue in this scenario.
Yeah, and sometimes, in particular, in the context of cross-border disputes, you don't really want to go to the local court because you want to have the effect over a party who is not based locally. And sometimes the respondent, the party that you want to seek the injunction or the interim measure against, may be a sovereign state. So it's kind of just as my colleague Kinlista correctly mentioned, I think it's a choice for the parties according to their requests and their interests.
Yeah, and really the provisions, particularly in Singapore seated arbitrations, are designed to work in complement. So if the institution is unable to act effectively, and if we look at, I guess, the boundaries of that, so if a party needed an order against a third party, if it needed to be ex parte relief, then maybe an application is going to be made to the court. The one thing, and it's a bit of an old joke that I often say, is there's very few courts in the world that can deal with an application for urgent interim relief at 1 in the morning on Friday night, early Saturday morning. And so that's where the advantage comes in. I think one thing, and all of you guys have a bit of a piece of this, and certainly the institution has a very big piece of this. We have seen an increase in applications for the appointment of an emergency arbitrator. During the COVID circuit breaker, I cannot think of a time where we did not at least have 1 or 2 emergency arbitrations ongoing. And so this is an important and very useful tool that we've been able to provide our users. And of course, we've got over 100 applications for the appointment of an emergency arbitrator now. I would like to say, Pauline?
Sorry, Kevin, I just realized I really haven't answered your question on transmission. I mean, just a very short answer. There's not really much change in terms of transmission. We have been issuing awards electronically and as well as physically in the past. We're still doing it. I think the only change after COVID-19 is that, for parties to, and as well as tribunal, to expect a slight delay in terms of, receiving the physical copies of the award. And I guess that's something that cannot really be helped. But I think the upside is, of course, that you get your award, the digital copy of the award. And when I say digital copy, really the preference at SIAC is to have the tribunal physically sign the award. So we're talking about a wet ink signature. We request the tribunal to send us a scanned copy of the award, and that will be transmitted to the parties by way of email. That's the short answer. Thanks, Kevin.
But we're still transmitting and sending by courier originals.
We are, yes, absolutely, yes, absolutely.
what we've seen and what I've observed on a few of your guys' cases, some prudent tribunals are getting the parties to agree to electronic notification, which I think is a very good idea during the time of COVID-19. But that's not going to change the institutional process. We are still going to send a physical copy of those original awards. If there are no other comments, I would like to thank our panelists, Chen, Candice, Pauline. Thank you very much for being here. I think that most of the attendees are very familiar with this set of counsel. One thing that we like to do at SIAC, whether it's by live chat or by email, we like to be accessible to all of our users. This is the third, and I'm not sure whether it's the final session of the Secretariat session, but if you found these useful, if there are any other topics that we should be addressing, please do let us know. Thank you all for attending, and we wish all of you a good evening. Thank you.
Bye-bye.